Hello, welcome to today's immigration tidbit. Well, first of all, it's up to the judge. Okay, the motion to vacate and or reduce is ultimately up to the criminal judge, and you don't always have to get it vacated. I mean, there's another part to this question which talks about the fact that it's an aggravated felony, and some aggravated felonies are dependent on the sentence. So, for example, let's say you have a crime of violence with a sentence of 1 year. That makes you an aggravated felon. Let's say the sentence is 364 days. That doesn't make you an aggravated felon, and a waiver is available. And if you have the green card, you're eligible for cancellation. So, that 1 day difference makes a huge difference in immigration law, makes hardly any difference in criminal law. So you don't have to go for the whole ball of wax to have it vacated, because you know what happens sometimes when it's vacated is they decide to recharge under another charge, and then you end up back in square one, trying to fight a criminal case again. Just because it's vacated doesn't mean everything's over. So, assuming it's done properly, the fact that it was done before 1996 is just factual, okay? Whether it happened yesterday, whether it happened before the 1996 IRA laws, whether it happened after, it's all factual. It depends on what the laws were at that time. Um, Before 1996, the laws weren't as strict as far as, different criminal laws. So it may not have been an aggravated a felony at the time that he pled, yet the time he got out of jail, or now it might be. In which case, I would need to also know, did he have the green card? Did he apply for what's called 212C relief? Because 212C relief disappeared after 1996, except it actually, for certain circumstances, came back in 2001 under a Supreme Court case. So I'd need to see if, in fact, he needs to vacate, because maybe, it's just a matter of making motions to reopen to get back to immigration court to properly apply for 212C relief. Now, back specifically to your question, though, in order to get it vacated or reduced, it cannot be because of immigration. I mean, we all know you're doing this because of immigration, but the order to vacate or reduce cannot be because of immigration. Unfortunately, there's people or lawyers who are not immigration attorneys who do this, and they think they won, but they didn't. Like, for example, they'll get an order saying this crime is vacated because this court is sympathetic to the immigration plight and this defendant already served his time, something like that. Well, that's not going to cut it in immigration law. The second that they see that, let's say this is not valid for immigration purposes because it's just rehabilitation or it's done to get relief in immigration. So, assuming it's done properly, you have to look at what happened. Now, I know that the other part of this question is you essentially said that, sort of the gang mentality, and he was uh, just being quiet, not saying anything, and taking the blame. Um, you realize that by trying to vacate and saying that, they will all think he's lying. Okay, so it has to be done very methodically, very carefully, but minus the fact of that, and more importantly, is whether it was knowing and voluntary. For example, did they say to him something to the effect, if you don't plead to this, you're going to get a guilty plea for this or that, or a guilty conviction for this or that, and you're going to end up 20 years in jail. But if you do this, you're going to get a year in jail and be able to go on your merry way and just get out and no problems. Or did they tell the truth, saying that if you plead to this, you're going to be considered an aggravated felon under immigration law, you will likely be deported for the rest of your life, you will never be able to come back? I mean, if they told what the truth was, what the reality was, they would not plea guilty to that. Which brings up, when someone is pleading guilty, you always have to get an immigration attorney to evaluate the situation. Do you remember at the beginning of this when I said that one day makes all the difference in the world? Nobody but an immigration attorney is going to know about that. Okay? And the judge, the prosecutor, they're not going to care about one day. They're going to figure he served, pretty much a year what he was going to get anyways. What's one day to them? But it's everything to the immigrant. So in this case, it may be possible, if he really didn't know about the consequences and he didn't know about the true consequences, so the plea wasn't knowing and voluntary, to make the motion. It doesn't hurt, but don't keep doing it over and over again and think you're going to get different answers. Just make sure it's done right the first time. Okay?